ADR and ODR are faces of the same coin.
Good evening, dear friends. I am Advocate Manuel Rivera. It gives me great pleasure to welcome all of you on the occasion of this webinar on online dispute resolution. This platform is particularly intended to resolve small and medium value cases using digital technology and also the techniques of alternate dispute resolution like negotiation, mediation, arbitration, conciliation, etc. This webinar is organized by SoftSettle support with the cooperation of ICADR, International Center for Alternate Dispute Resolution. ICADR is working under the aegis of the Honorable Supreme Court of India and based in New Delhi with zonal offices in Bangalore and Hyderabad. SoftSettle Support is a startup company promoted by legal and software professionals. As far as I know, SoftSettle Support may be the first venture in India committed to digitalize dispute resolution system with automated or robotic stimulated software. Alternate dispute resolution is approved by the law of the land and is much highlighted and implemented by the justice delivery system of the country, right from the Honorable Supreme Court down to the Municipal Court. In alternate dispute resolution, the parties come to a table and discuss the issue in the presence of the mediator. But in the present scenario of pandemic COVID-19, physical presence of the parties for dispute resolution is very difficult and unviable. Here is the relevance of online dispute resolution. The parties and the mediator can participate in the process from their own ambience. This would help minimizing effort, time and cost. We are proud and privileged to have Advocate Prashanth Chandra, the Senior Mediator and Faculty of Bangalore Mediation Center, and he is here to deliver the keynote address on the subject. It is to be particularly mentioned that he is an authority on the subject with so many books to his credit. On behalf of SoftSettle Support and Advocate Mirza Sahir, the backbone of SoftSettle, I warmly welcome Advocate Prashanth Chandra to this August program. I also welcome one and all of you who have found time to participate in this webinar in the midst of all your busy schedules. Now, on behalf of all participants, I respectfully invite Prashanth Chandra to address the participants. Thank you and have a nice time.
We thought that there was only one alternate, that is court. We were all rushing to the court for getting our redressal. Now, alternate being blocked, alternate being stopped, alternate not being not able to function, naturally we have to look at the alternatives. So therefore, if you remember and recall, the first few months after March 2015, the focus was what is the alternative to the court. And the unanimous opinion of most of the legal experts is ADR is the alternative to the functioning of the courts, slow functioning of the courts or non-functioning of the courts. April, May, June, we had a lot of webinars, discussions here and there among the legal fraternity, even among the business people. How do we get justice, quicker justice? So the probably if I see, or if you just go back to YouTube and see, the first 3 months, the focus was on ADR, May, June. After June, ADR is already taken for granted as the only remedy. It is only the alternative. No, alternate to alternatives we have already moved. Now, June onwards, we are already looking at ODR because ADR is part already of our life. Now, how do we express or how do we go through this ADR? So ODR is effective in dealing ADR. So I would only say ADR and ODR are faces of the same coin. Both are required to see that we get effective justice. Thanks to that pandemic period, we have learnt an alternative. Now, alternate to alternative is the advantage which we have got in the last 200 days. And this is the momentum now where we have to start picking up from this and take the advantage of ODR, and it has to proceed further. And I would also go one step further and say this could be this could pave way for privatization of the courts. Now, with organizations, private organizations like SSS and many other organizations which are there already in the field of arbitration, conciliation, and mediation, already the judicial dispute redressal system has already become sort of privatized. Now, these are the organizations, because that's also the motto of Niti Aayog, to see that it is all privatized and people who are competent, without they being part of the judicial system or the government, they can themselves do the role of adjudicators, try to see that justice is delivered to the litigants. So this could be another major change which we probably see in the next few days. So lastly, coming to the advantages, definitely it will lead to transparency in the dispute redressal system. The entire dispute redressal system will be transparent, and we'll have to accept it, and it will become a new beginning of the judicial system in India. I was just going through and trying to understand what could be the laws which we as practicing advocates and arbitrators and mediators we have to concentrate on when we say ODR. According to me, maybe it's a few sections of IT Act we have to understand. If I'm right, section 4, 5, and up to 10 of IT Act. Evidence Act, which you are already using, section 65A and 65B, recording of evidence, electronic evidence. Arbitration and Conciliation Act, section 31, insofar as award, as I said, enforceability, these are issues which have to be properly clarified in the Arbitration Act. When it comes to delivery of award, jurisdictional issues, the state government and the state high courts have already framed rules for video conferencing of courts. Few of the states have done it. I, coming from Our Karnataka High Court has already framed the rules for this in the month of June 2020. Some other courts have already framed. Probably we have to adopt this also for our ODR. Standard operating procedures are also there, which we have to probably study and examine and see that these are tinkered to see that ODR is accepted and ODR becomes part of that, and even the courts accept these ODR settlements. We have the Commercial Court Act, which is my favorite subject, where certain concepts are there which could be probably effectively tried in arbitration. Of course, in mediation and conciliation, it is not adjudication and it is nothing to do with adjudication. Therefore, that will not come. So when I'm talking commercial court and case management system, in arbitration, probably the procedures have to be changed to see that we adopt maybe a concept of case management system of the commercial court to see that this is also implemented in the court, in the arbitration system. There is something called as admission or denial of documents, which can save a lot of time in the cross-examination, which is being effectively tried in the Commercial Courts Act concept. And that could be probably made part of the ODR, where we adopt this to the arbitration. Discovery and inspection of documents. These are all main things which I found it from Commercial Court Act. Because when it comes to arbitration, the procedures of arbitration are determined by the parties, or in the absence of an agreement between the two parties, the arbitrator decides. So the arbitral proceedings insofar as ODR is concerned, that is to say ODR, which is arbitration, they can adopt this Commercial Court Act concept to some extent and see to it that these are made part of the procedures, which means the evidence, huge volumes of evidence can be reduced and it can be made in the form of question and answer as provided under discovery and inspection documents.
Thank you, Mr. S.N. Prashanth Chandra. It is not only the short and sweet speech, it is the short and swift also. I am very much thankful to Mr. Prashanth Chandra for his excellent outcome speech on this ODR. Before rendering my vote of thanks, I request Mr. Vivekananda, S.K. Vivekananda, the Governing Council of this ICADR, to acknowledge the speaker and the audience viewers here.
Thank you very much, Prashanth Chandra. It was very, very nice. Thank you, Rathod ji. Thank you, Sundaresh ji. Thank you, Manuel Vivera ji, ICDR, and SoftSettle support. It was a really good beginning, and we'll be having a lot of webinar like this in future. Thank you, everybody. Take care of your health.
I extend my heartfelt gratitude to Mr. S.N. Prashanth Chandra for his excellent speech on this ODR. It's a new one. I know it's a new concept, but it is very essential for the reason what the topic itself says, because of if we book the ticket in air ticket airlines, we cannot take back the refund also now because of no flight. Our money drained into the airlines financial, there's a locker is there. Therefore, in the view of this, ODR has made enormous changes now. We can file a writ petition against the airlines. We can file some of the complaints against the airlines only through ODR. And even we cannot touch this any aspect in this COVID reason. Therefore, the topic is relevant nowadays, and even we cannot file a complaint or dispute or any appeal before the High Court. We cannot reach the High Court also because of the fear about the COVID-19. Therefore, in this time, in this aspect, more and more ODR concepts, the subject has to be introduced in this webinar. And in this aspect, I acknowledge very much. I'm very thankful to Mr. Insaf P. Mirza and Mr. Khalid B. Mirza, who are the directors and promoters of this SoftSettle Support Private Limited, and also Mr. S. K. Balachandran, Mr. V. K. Pratap Chandran, Mr. Isaac Abraham, Mr. Manuel Rivera, Mr. Mirza Zahir, who are all the advocates, and also the expert panel of this SoftSettle Support Private Limited, and also Mr. K.S. Munir and Mr. S. Yogindranath and Mr. Jairaj Soundarajan. Those are all pioneers of this company, that is SoftSettle Support Private Limited. And also I acknowledge to our Mr. Atul, who is a technical expert and doing well on this, and made it easy to for this webinar. And also I acknowledge the thanks to Mr. R.K. Rathore, our Secretary, Honorable Secretary General of this ICADR, and I extend my thanks to Mr. S.K. Vivekananda, the Governing Council of this Bangalore Center, ICADR Regional Center, and viewers and participants. And this is not only the last the program, this is the first and initial program launching on this ICADR after a long time. We had the physical so many programs in and out of the Bangalore, all districts and in India, this ICADR. But this is the first time we reached Kerala also on this ADR. I extend thanks to each and every one of the SoftSettle Support Limited and also ICADR panel, even including the ILR editor, M.N. Umashankar, and Anu Changappa, who is there as a viewer here, and other advocates, mediators, panel arbitrators, and many more. The like members of ICADR are also there in this as an audience, and Mr. Pratap Kumar and Sanjay Kumar is there as an audience to appreciate the speech of this Mr. S.N. Prashanth Chandra. I thank one and all, and good evening for all the viewers and the imagination. Thank you one and all. Thank you, sir.